We're continuing with Chapter 2. In fact, we're going to finish Chapter 2. Chapter 2, Section 5 deals with ratification and the Bill of Rights. If you will look in Google Classroom, you will find that the notes are there for you. And so as we go through this presentation, please fill in anything that you see in red on the screen into your Google Notes, and then you will submit that for a grade when you're done. Okay, in Google Docs, in your notes that are in Google Docs is what I'm trying to say. Anyway, feel free to pause at any time you need to make sure you stay on top of things, and let me know if you have any questions when it's over. Okay, so we've looked so far at the Constitution and how it came about. The first Constitution we had was the Articles of Confederation. It was a very weak national government. The state governments were very strong, and they did it that way for a reason, because they were trying to protect us from having a tyranny like what they believed we had with the strong national government in England. And so they had created it that way. But they had many of the founders come to the conclusion that the national government needed to be stronger because there were too many crises and the government didn't have enough power to deal with those. But once the founders met in Philadelphia and drafted a new constitution, then they had to ratify it. Ratify means to formally approve. So make sure that you know that term. That's a term that you should be familiar with. So they had to find a way to ratify this constitution. How do you get it formally approved? And the Anti-Federalists were the people who were opposed to the Constitution on general terms, and the Federalists were those who were in favor of it. Now think about why they would be called that, Anti-Federalists. They were against. Anti means against a strong federal government. The Federalists were in favor of a stronger federal government. So that's where those names came from. Okay, so the first question we need to consider today is, what were the main points of disagreement between the Anti-Federalists and the Federalists? So what were their main points? We could get into a lot more detail, but we're just going to talk about the general purposes, the general points of disagreement between the two groups. First thing we see is that the amount of strength of the national government was a point of contention between them, a point of disagreement. The Federalists felt like that in the Constitution that had been drafted, not yet ratified, but they had been drafted, that would strengthen the national government and give it enough strength to do what needed to be done, but also that it would be somewhat limited in what it could exactly do. The Anti-Federalists, however, believed that the national government, as outlined in the Constitution, would have too much power and could the president could become like a king, and there could be tyranny in the country. So they were afraid of that. The second thing that they were debating over was whether a large or a small republic was best suited to protect individual liberties. The Federalists believed that a large republic with all the states together and a strong national government, that the strong national government could protect the rights of individual people, the liberties of individual people. They believed that because they believed with the country being larger and more diverse, that could prevent a small group from taking over and enforcing their will on others and not protecting minority rights. And that's what they believe, that a larger, more diverse country would be easier to protect the rights of individuals. But the Anti-Federalists disagreed with that. They felt like that a smaller governmental unit, such as a state, as it was listed under the Articles of Confederation. Remember, the states had a lot of power under the Articles of Confederation, that because the state governments would have been closer to the people, that the people would have more influence over that government, and therefore their individual liberties would be protected. So that was another point of disagreement between the Federalists and the Anti-Federalists. And the third point that we want to look at is whether a Bill of Rights was necessary to be included in the Constitution. The Anti-Federalists said, if we don't put a Bill of Rights in the Constitution, then the government would be able to maybe run over those rights in some way. But if we put a Bill of Rights in there, then possibly we can limit the power of the federal government in relation to the individual liberties. Okay. Now, most states, if not all states at the time, and there were 13 states, remember, did have a Bill of Rights in their constitution. So the Anti-Federalists just wanted the national constitution to be the same as their state constitutions. The Federalists, on the other hand, didn't believe that there was a need for a Bill of Rights. They believed that it was just naturally going to be protected and they wouldn't have to worry about it. In fact, James Madison, who is kind of the father of the Constitution, was a nickname he give him, he didn't believe that it would be needed at all. He just felt like that if you had it in there, it really wasn't going to prevent the federal government from doing it if they wanted to do it. So he didn't think it would stop them, but he just also felt like that for the most part, they probably would be protected anyway. Now, I have to be fair and say that a few years later, he changed his mind on that. But at first, he was against it. Okay, so the second question we're looking at is, why did the framers think that the state legislatures would probably be against the proposed Constitution? So as the Constitution was finished in Philadelphia and they put it out for ratification to the states, they set up a ratification procedure that would basically bypass the state legislatures. They didn't want the state legislatures or the Congress under the Articles of Confederation to vote on this Constitution because they believed that they would probably be against this Constitution. Why did they think they'd be against it? Well, let's look. They believed that they would be against it because this new Constitution actually reduced the powers of the states by quite a bit. So what state legislature would vote to approve a Constitution that would then reduce its power? They didn't think that would happen. So that's why they had it set up to where in each state, people would elect representatives to go to a constitutional convention and then vote yes or no on ratifying the Constitution. So the people would select the representatives. If you were in favor of the Constitution, you would vote for someone who was in favor of ratification. If you were against it, you would vote for someone who was against ratification. And so that's why they did it that way, because they were afraid that these state legislatures, fearing losing power, would vote no. So they just bypassed them altogether. Okay. Now, the next section of Chapter 2.5 is the Federalist Papers. Once the Constitution was put out there, there was a set of people who started publishing papers that were printed in news. They were actually articles that were printed in newspapers throughout the colonies, or the states, I should say. And these three men were Alexander Hamilton, James Madison, and John Jay. Now, Alexander Hamilton and James Madison wrote most of the Federalist Papers. John Jay was tied up in other business issues, and I think he was an ambassador, and he was out of the country a lot, so he didn't write very many of them, but he was part of that. These papers were basically a defense of the Constitution in detail, and there were quite a few different essays. There were a total of 85 essays that they wrote, authoring these that they wrote to promote the Constitution. Now, there was a group of people called the Anti-Federalists that wrote the Anti-Federalist Papers, and basically it was the same thing, but they really didn't have the same influence or impact that the Federalist Papers had. So let's look at the questions. We're looking at that. What were the main arguments made by the authors of the Federalist Papers? And really, with 85 different essays, we could go and we could look at a lot of different arguments, but let's look at the main ones. The first thing that they argued was that the federal government should act to balance the influence of factions. Now, when I say factions, that means groups. We would look at them today as political parties. That would be a faction, or interest groups. I think of the Small Business Administration, the National Rifle Association, the National Organization of Women, those things like that. Those groups where people organize themselves around an issue or certain types of issues like women's rights or gun rights, or around a political party, something like that. Those are factions. And so what they felt like is if you had a strong federal government, the way it was set up in the Constitution, that would be able to balance out the factions that would naturally form. Now, they did not really want factions to form, or groups or political parties. They really didn't want that to happen. But James Madison, in one of his that he wrote, knew that was eventually going to happen. You just can't stop people from forming groups based on common interests. You just can't do that. But he thought if we had a good, strong federal government, that we could balance out those influence. So that way one faction wouldn't have ultimate power over the rest of them. Okay. A second thing and a third thing that they argued was that the separation of powers was vital, and we'll talk about the next one in a minute, but the separation of powers was vital. What is separation of powers? Well, our government has three separate branches that have equal power, and they have equal responsibility in the government. So you have the executive branch with the president and the vice president. You have the Congress, which has two houses, the Senate and the House of Representatives, and they make the laws. The president enforces the laws. And then you have the judicial branch, which is made up of the Supreme Court and lower courts, that interprets the laws. Okay. And so they felt like if you had three separate branches of government that that had equal power, then they would then balance out each other, and that was vital. They also felt like a system of checks and balances were vital, were very important. Checks and balances. So in other words, when Congress passes a law, a check and balance on that is that the president can either sign that law or he can veto it. And of course, they have a check and a balance on the president because if he vetoes it by a 2/3 vote in the Congress, both houses of Congress, they can override that veto. There's a check and a balance that the president has over the courts because the president actually appoints the Supreme Court justices and other judges. And the legislative branch, the Senate, confirms those, okay, or not. So that's the way it goes. So we have this system of check and balances that allows our government to keep the other branches of government in balance, okay? Who was Publius? Because the name signed to every one of those 85 essays was Publius. So at the time these were written, almost nobody knew who these authors were. We know now, but they didn't know then. And so they would sign these papers as Publius. So who was Publius, and what does the name mean? Well, Publius was the pen name. When a person writes something and they don't want everybody to know who it was, they use a pen name. Mark Twain, for instance, was a pen name. That man was not actually named Mark Twain. His real name was Samuel Clemens, but he authored his books under the pen name of Mark Twain. So Alexander Hamilton, James Madison, and John Jay used Publius as a pen name, and they used that name to honor a founder of the Roman Republic because they felt like they were founders of the American Republic. So they were going to honor him in that way. So that's who Publius was, okay? The third section we want to look at is the fight for ratification. Ratification means formally approving of something, okay? So number 5, why was the Bill of Rights important to the ratification of the Constitution? Many states would not have ratified the Constitution without the promise of a Bill of Rights. Why would they have not? Because there were enough people who were anti-federalists that said, if you will put in a Bill of Rights, we will go ahead and agree to vote yes for this Constitution. Okay. Now, there were a lot of anti-federalists who weren't going to vote for the Constitution under any circumstances, but there were enough who were opposed to the Constitution simply because there was no Bill of Rights. And so the Federalists, who really didn't see a need for the Bill of Rights in the Constitution, finally came on board and agreed that we'll put one in the Constitution. So in the very first Congress, James Madison was the Speaker of the House of Representatives. And remember, he didn't believe that they needed one, but he introduced he introduced 12 amendments to the Constitution, 10 of which were approved and became the Bill of Rights, okay, that were ratified. So there were enough people in several of the states where the vote would have been close that said, if you'll put a Bill of Rights in the Constitution, or if you'll agree to it, we will then vote yes to ratify. And so if they had not done that, the Constitution may never have been ratified. And number 6, what feature of the Constitution encouraged small states to adopt it? Now, remember, we talked about this before. The large states wanted Congress to be based upon population, the number of representatives from each state to be based on population. The small states wanted to be based on every state getting the same amount. And both sides couldn't agree to the other side. So they said they compromised. Remember, you had the Senate, which has 2 senators per state. So every state got the same number of people. And then you had the House of Representatives, which every state gets their number of representatives based on population. So the thing that convinced a lot of the small states, like Rhode Island, those kind of states, to come along and adopt the Constitution was that they would have equal representation in the Senate. In other words, they would not have their voices drowned out as badly. Now, the Bill of Rights came along in the early 1790s after the Congress proposed them and sent them out for ratification. Enough states ratified them that they were adopted. The actual Constitution was written in 1787, and the provision in the Constitution was that when 9 of 13 states ratified, it would become the law of the land. The 9th state ratified in 1789. So 1787 it was written, 1789 was when it was ratified and went into effect, and that's when George Washington was elected president in early 1789, and he became the first president then on March the 4th of 1789. All right, if you have any questions, let me know. Don't forget to submit your notes for a grade. Have a good day.